about to commence as everything is set. We have SSBC inside the only media outlets covering this hearing until the end. So we shall be updating you about these proceedings, legal proceedings, commenced on Monday. The first time in the history of the country having this legal, having the trial against the. Okay, now you can see the two legal team are greeting themselves. They are showing that the chemistry is really vibrant. They are laughing. They are greeting each other. The defense team and the prosecution team are greeting themselves. They're quite of a reminder that this is all about testing the country's justice system. You know, nobody is above the law, and everyone is expected to respect the country's constitution. This is not about targeting, but it is kind of testing the constitution of the country against anybody trying to suspend, sabotage the coalition government, the transitional period. Now, for the meantime, I'll give the microphone to my colleague Leila Osman to give you more updates about these proceedings. We have not yet started.
Thank you, Madam Joseph, for the highlight. Actually, as a reminder again, Dr. Riek Machar stands accused of supporting terrorism, damages of properties, among other allegations, as we await for more proceedings from the judgment. He is accused, but not until proven guilty by the courts of law. This legal proceeding is a test not only on the strength of the judicial system of South Sudan, but also the country's commitment to democracy and legal norms. This is the first legal proceeding taken by the High Court of South Sudan, so the whole world and the whole country is awaiting to see the processes. We'll keep updating you. Please stay tuned with SSBC for more details. The court proceeding has not yet begun. The judges are already in place, and we're still waiting for confirmation of the legal and numbers of the judges. Then and other practitioners will give you more details on that based on incoming events. Thank you. Madam, over.
Okay. Thank you, Leila Osman. Before I give it to my colleague Peter Mori, I would like to bring to your attention that the proceedings have not yet started. We shall hear more testimonies, more evidence about this case, because the judges will now be able to present the testimonies, evidence regarding this case against Dr. Riek Machar and his associates, including Report Kang Shual. And when the proceedings commenced, they will be able now to give more evidence, and the defense team will be able now to present their objections against, the evidence are still lacking. But now we cannot conclude by saying that, because the proceedings have not yet started. We shall get more details when the program is started, whereby we shall be seeing judges, the official judges managing this trial against the suspended first Vice President Dr. Riek Machar. We have no more things to talk about, but the hearing, when things happen this way is another way of saying that the coalition government is committed to stability, security, whereby anybody trying to sabotage or to cause commotion or environment, the law stands against anybody trying to destabilize the country. It's another way of telling the public, the citizens, that it is significant for the country to stay stable. Now we are going to the studio where Gori Anthony will be talking more about these proceedings as preparations are ongoing. When we come back, we shall tell you the commencement of the hearing. Thank you.
Yes, that was my colleague Martin Joseph and Leila Osman. We have Mori, plus Martin Justin Kose giving an update on what is happening at Freedom Hall. As you people have seen, and our viewers all over, plus members of diplomatic corps, I'm sure most of them are now following us, wanted to see exactly what is happening and what is the next move after this court. And this is the question that is lingering on the mind of everyone, that what next? From here, of course, until the accused are proven guilty. But up to where we are now, it is right now where the court hearing will start. And it will start as soon as the presiding over judges, they have already arrived. There's some bit of arrangement that they are coordinating to ensure the commencement of the event at Freedom Hall. Of course, the saying goes, justice in 3 words: the quality of being just, impartial, and fair. In another word, fair, open, and impartial. And this is the guiding principles of rule of law that will take place from today. As you've seen, of course, we have seen the family members of the accused already at Freedom Hall. They are there to give a support to their, family members. You've seen Dr. Riek Machar. You've seen Honorable Potkang. You've seen also Lieutenant General Doklam. You've seen also Mampal. Then we have Brigadier General Camilo, as well as Mading Riek, and then Dominic Gatkok Riek. All of them are there and awaiting the process to commence. This is to ensure that the process of hearing by government or the legal team, you've seen the legal team, are now getting on the stage. These are the presiding judges, 3 presiding judges, as you could see, viewers. They have taken over their seats, and from here onward, of course, we will get to hear more. That family members of the accused are already there, and you have the government.
Be seated.
Yes, viewers, the 3 presiding over judges have already arrived. Back to where we say that the culmination of this event is due to the fact that Nasser incident that took place back in the days, that is in March, and this will be the turning point in the judicial system of the country to ensure that rule of law is put into place, and those who are against the law are actually judged accordingly. And if they are proven innocent, that is what will happen. As what is going to happen, we'll be hearing what is happening as the accused already arrived, and the judges, presiding over judges, you've seen them at Freedom Hall. And back, the government made it clear that rule of law must be upheld too, or people must adhere to the rule of law. The essence of the rule of law is to ensure that people respect the rule of law and adhere to it. Viewers, let's connect you to our colleague as the proceeding commences at Freedom Hall. Stay tuned with us in this live broadcast on the special court.
Pour les jetteurs dans la rue, les définitions, quoi qu'il arrive dans la mer, 4 milliards de mégots viennent polluer la planète chaque année. Alors les opérations citoyennes tentent de changer les mauvaises habitudes. Une école diplomatique importante à l'eau de la reconnaissance de l'État palestinien par une dizaine de pays, le Royaume-Uni, l'Australie, le Canada et le Portugal. justice s'est démenée ces derniers mois, je viens pour défendre la reconnaissance de l'État palestinien. Oui, il y a d'ailleurs une réponse très symbolique.
First of all, we would like to start by saving the parties the order of the establishment of the court. The step number 2 is that we would like to read out the audience ground rules. First of all, before the beginning of the proceedings, we would like to be reminded that the law provides for public trial, meaning that the court is open to everybody. Including the media. However, the public has a duty to keep peace in the courtroom. Therefore, there is need to comply with the following. Number 1, the media houses are required not to conduct themselves only in accordance with the national laws. For instance, the Constitution, Media Authority Act, National Communication Act, Access to Information Act, Penal Code Act, National Security Act, and any other relevant laws in coverage and reporting, but also in accordance with the international law. Number 2, no movement while in the court. Nobody is allowed to move since he has entered into the court. Number 3, no to talk. You just listen. Number 4, phones shall be in silent. You will never be allowed to speak while you are in court using your telephone. Number 5, no smoking in the court. Nobody is allowed to smoke. Send away any media apparatus or any person who fails to observe the above requirements and may decide to go for closed proceedings or take legal measures against anyone who is not able to attend. The process. And I hope all the parties are in their places. The prosecution is there and the defense is there. Of course, the court is going to take your attendance.
I wanted the attendance of the parties.
Honorable Court, this is Denga on prosecution panel.
Good morning. Dr. Sopriwani Lanu, Consul General Minister of Justice, member of the prosecution panel. Thank you.
Good morning. My name is Simon Meza, Consul General in the Ministry of Justice, member of
Your voice, please.
Sarafino Simon Mezan, Consul General in the Ministry of Justice, member of the panel. Thank you.
Filberto Maywood Maran, Consul General in the Ministry of Justice on the prosecution panel. Thank you.
Advocate Ajo Onyoisa, a member of the prosecution panel.
Advocate Gabriel Mading Apache, a member of the prosecution panel.
Judge Advocate Deng Mabur Deng, member of prosecution panel. Ustaz Phillips and Yang Wong, member of the prosecution panel. Who? Phillips and Yang Wong, member of the prosecution panel.
Ajak Mayol Pure, Your Honor, member of the prosecution panel. Advocate Ajak.
Advocate Martha Jovita Jeremiah, member of the prosecution panel.
My lords, my name is James Paul Michael, member of the prosecution panel. I am Advocate Peter Garab, member of the prosecution panel. Second Legal Counsel, Your Honor, Boto C.I. Sadio, member of the prosecution panel. Here, John Investigator, member of the panel. Major General Sergio Thomas Wani, investigator. Sergio Thomas Wani, investigator. Member of the prosecution panel. Legal Security Riek on behalf of National Security Internal Security Bureau complaint.
Please repeat.
Captain Legal Security Riek Apollo Musa, behalf of National Security Service Internal Security Bureau complaint.
Good morning, Your Lordship. Advocate Dr. Gary Raimondo Lege Lobate, the lead defense team. Thank you.
Please speak one by one.
Advocate Dr. Gary Raimondo Lege Lobate, the lead defense team. Thank you.
Next.
Bismillah ar-Rahman ar-Rahim. Al-Ustaz Kur Luad Kur al-Muhami, عضو هيئة الدفاع.
Ustaz Anis Tombe Agustino, عضو هيئة الدفاع.
Repeat, please.
Ustaz Anis Tombe Agustino, عضو هيئة الدفاع.
حضور الأستاذ دين جون دين، عضو هيئة الدفاع. Who? دين جون دين. الأستاذ دين جون دين، عضو هيئة الدفاع. Next.
وحضور الأستاذ وارنيان كير وارنيان، عضو هيئة الدفاع. وارنيان كير وارنيان، عضو هيئة الدفاع.
السلام عليكم. روجينا الكريودين، أستاذ روجينا الكريودين، عضو هيئة الدفاع.
Next.
شكرا مولانا.
The accused persons.
Port Kang Chol.
The voice is not clear, please.
Port Kang Chol.
Mam Tal Dwar.
Yes, not clear.
Mam Tal Dwar.
Gadwich Lam Poch. Gadwich Lam Poch. Camilo Gatmai Kel. Camilo Gatmai Kel. Riek Machar Teny. Lieutenant General Gabriel Duop Lam.
Please repeat.
Lieutenant General Gabriel Duop Lam.
Mading Yak Riek.
Dear Riek.
Mading Yak Riek.
Next. Dominic Atgo Riek.
We have done with the attendance, and then now we would like to proceed for the two parties, whether there is any observation. Is there any observation from each of you? Yes.
Your Lordship, we have an objection for establishment of this Honorable Special Court by His Lordship, the President of the Supreme Court of the Republic of South Sudan, Honorable Justice Dr. Benjamin Bagdeng, to constitute this special court for the following grounds. His Excellency Dr. Riek Machar Teny is governed by the provision of Article 103 read together with Article 104 of the Transitional Constitution of the Republic of South Sudan, read together with the provision of regulations, conduct of business regulations, which I read. This is here. Transitional National Legislature Conduct of Business Regulations 2013 as amended 2021, read together with the revitalized agreement signed on 12th of September 2021 18 read together with incorporation of this revitalized agreement into our Constitution's Amendment number 6, 2020, His Excellency, in case of impeachment, and the same provisions applies to His Excellency, the first Vice President, Dr. Riek Machar, which is stipulated in Article 126, which avails His Lordship, the President of the Supreme Court, to establish any court. Your Lordship, this court is not for people like His Excellency Dr. Riek Machar, who is governed by the revitalized agreement, and this court supposed to be, impeachment of His Excellency supposed to be in accordance with the Article 103, Clause 2, should be through passing a resolution by two-thirds majority of the national legislature, which is stipulated here and in the Constitution. And for us, we were really, thank you, my colleagues, for the dream we have done. It's already here. We have done this, and this is what our defense. Let me read. It is here. What did I say?
So this is the objection in writing.
Yes, this is objection in writing. I'm going to read to the Honorable Court because we are making history to this Republic.
It's okay, that's good.
Thank you. It's a history. And it's our time to do that. The Republic of South Sudan, the judiciary, in the special court for Nasir incident at Juba 2025, in the matter of trial of accused His Excellency Dr. Riek Machar and 7 others, criminal case number 1533 of 2025, brought under sections 48, read together, sections 50, 52, 60, 61, 64, 65, 66, 67, 70, 71, 72, 75, 76, and 2006, which is the mother, and section 239 of the Penal Code Act 2008, read together with section 15A, B, and 16 of Anti-Money Laundering and Counter-Terrorism Act 2012 as amended 2024, subject objection on lack of jurisdiction of a special court to try His Excellency Dr. Riek Machar, the first Vice President of the Republic of South Sudan, and his colleagues, the 7 accused. Your Lordship, Honorable Justice, the President and members of the Special Court, we act for and on behalf of the accused, His Excellency Dr. Riek Machar, the first Vice President of the Republic of South Sudan, as the first accused, put Kamshol, our Minister of Petroleum, number 3, Lieutenant General, put Gabriel Dup, number 4, Mam Pal Dor, and my age mate, my colleague, Garwich Lam Foj, number 6, Brigadier General Camilo Gadmal Kel, Mading Riek Yak, and Dominic Gadrog Riek, respectively. We submit this preliminary legal objection to this Honorable Special Court, challenging the jurisdiction and competency of this Special Court to try the above accused person on the ground of revitalized agreement on the resolution of the conflict in the Republic of South Sudan, and also constitutional immunity to His Excellency Dr. Riek Teny, the first Vice President of the Republic of South Sudan, and constitution in establishment of this special court by the Honorable Justice President of the Supreme Court of the Republic of South Sudan, and violation of international treaties, conventions which South Sudan has assent, and regional human rights norms. 1. Ground for legal objection: supremacy of the revitalized agreement on the resolution of the conflict in South Sudan, 2018. The revitalized agreement on the resolution of the conflict in the South Sudan is binding upon the government under both constitution and international laws, and superior to the constitution pursuant to provision of Article 8, Clause 3 of the revitalized agreement, which is to play. This revitalized agreement shall take precedence over any national legislation, any existing agreement to the contrary, and in the event that the provision of a national legislation or previous agreement conflict with the term of this agreement, the provision of this agreement shall prevail. As a matter of binding constitutional incorporation, the revitalized agreement on the resolution of the conflict in South Sudan under Article 5, Clause 3, Paragraph 1, Subparagraph 1, provide for the establishment of hybrid court for the South Sudan, which is stipulate that there shall be established an independent hybrid judicial court, the hybrid court for South Sudan. The court shall be established by African Union Commission to investigate and, where necessary, prosecute individuals bearing responsibility for violations of international and or applicable South Sudanese laws committed from 15 December 2013 through the end of the transitional period. Your Lordship, crucially, the hybrid court for South Sudan constitute the sole judicial forum visited with jurisdiction under the revitalized agreement to entertain allegation of violation of international law and other grave breaches of grave breaches of the laws of South Sudan attributable to the parties to the agreement. Consequently, if the Nasir incident is to be characterized as transcending a mere ceasefire violation and amounting to a serious crime within the purview of international or national laws, then the matter falls squarely and exclusively within the jurisdiction of the hybrid court, which has never been established by the African Union Commission of Human Rights. Your Lordship, the hybrid court has been designed and agreed to have its own bill, investigations, and prosecution mechanism. This is what His Excellency Dr. Riek Machar and his colleagues and the rest have agreed. Just as the revitalized agreement has primacy over all laws of South Sudan, including our beautiful constitution here, this beautiful constitution here, our constitution, the hybrid court is also invested to have primacy over all the national courts with regard to investigating and prosecuting serious crimes under international law and relevant laws of the Republic of South Sudan, which involve parties or individuals within the parties to conflict during the transitional period, as in the case under Article 5, Clause 3, 2 and 1 and clause Article 5322 of the Revitalized Agreement 2008, read together with the provision of Article 201A, Clause 7, Paragraph A, B, C, and D of the Transitional Constitution of Republic of South Sudan, Amendment number 6, 2020, which is here. It is already here. It is respectfully submitted that the office of His Excellency, Dr. Riek Machar Teny, it is respectfully submitted that the office of His Excellency, Dr. Riek Machar Teny, our first Vice President of the Republic of South Sudan, as the first Vice President of the Republic of South Sudan, together with the positions occupied by the 7 co-accused persons, derive their legal and constitutional legitimacy directly from Article 1, Clause 7 of the Revitalized Agreement on the resolution of the conflict in the Republic of South Sudan. Your Lordship, by virtue of these provisions, their offices and the mandate are a product of the peace agreement, which form an integral part of the constitutional and governance framework of the Republic of South Sudan. Your Lordship, basically, any purported criminal prosecution of the said offense barriers outside the mechanism expressly provided for under the Revitalized Agreement amount to a fundamental infringement, violations, transgressions of the agreement, undermines and delicate process of peace agreement, which we are yearning into, all of us in this hall and those who are outside. We were yearning into peace. We need peace in our country. We need reconciliations in our country. We need healing in our country. We need peace once again. Your Lordship, delegate any constituted breach, anything inconsistent with this agreement, which is incorporated into our constitutions by the heart of the people of South Sudan, constituted breach of South Sudan and international obligations. We have an international obligation. Your Lordship, the provision of Article 8, Clause 3 of the Revitalized Agreement provides unequivocal terms that the provision of the agreement shall take precedence over any provision of the Constitution, Transitional Constitution of the Republic of South Sudan, and any other legislation of South Sudan which may be inconsistent with it. Likewise, these oblige all organs and institutions of government to implement and comply with the agreement in both letter and in spirit. Furthermore, the provision of Article 9, Clause 3 of our beautiful constitutions of Republic of South Sudan, 2011, as amended, provides that all rights and freedom enshrined in international human rights treaties, conventions, and instruments ratified or acceded to by the Republic of South Sudan shall be integral part of this beautiful constitution. Your Lordship, these constitutional provisions elevates the Revitalized Agreement as ratified international peace agreement to the status of supreme law. The supreme law, the Constitution. It is the supreme law, it is the grand norm, it is the mother of the laws which all of us in this hall and outside we are binding to upon all authorities, including the judiciary of Republic of South Sudan and the Minister of Justice and Constitutional Affairs and our Minister of Interior and the National Security. All of you, your duty mandate by this agreement, it is above all of us. All of us, we are down of it, and this is the one governing our country, international. Since South Sudan, your Lordship, we are members of UN, as well as we are members of African Union, as also we are members of IGAD, and we are members of Northern Corridor, and also we are partners of East African Community, and you know, Article 6 right together with Article 7 of establishment of East African Community stipulates adherence to fundamental rights, rule of law. In light of the foregoing, any criminal proceeding instituted against His Excellency, Dr. Riek Machar, Teny, our first Vice President of the Republic of South Sudan, or the co-accused who are here, outside the framework of the revitalized agreement, particularly in this regard of the hybrid court for South Sudan, envisaged under Article 5, Clause 3.1.1 of the agreement, are ultra-various, beyond the power even of the Chief Justice above. It is unconstitutional, it is illegal, it is unlawful, and therefore it is null and void ab initio, without any legal effect. Therefore, they continue pursuant of this trial by this Honorable Special Court, which I respect it properly. I respect this Honorable Court. The constituted process of this trial before this Special Court not only lacks jurisdiction foundation, but also places the Republic of South Sudan in manifest breach of its obligation under both domestic and international laws. For the avoidance of doubt, the revitalized agreement signed on 12 September 2018 in Addis Ababa remains valid and binding, and no derogation therefrom is permissible without express and formal abrogation in accordance with due process of the law. Number 2, jurisdictional and procedural objections on constitutional immunity of His Excellency Dr. Riek Machar, our first Vice President of the Republic of South Sudan. First and foremost, we want to bring to the attention of this Honorable Special Court that the instance of preliminary legal objections pertaining one of jurisdiction of this Honorable Special Court is that the legal objection meant to terminate an infancy or as well to nip it in the bud without wasting the time, dispersing unnecessary energies in considering unworthy or fruitless matter in the court proceeding. It, in other words, forecloses hearing of the matter in order to save time. Your Lordship, Article 103 and Article 104, Clause 2 of the Transitional Constitution of the Republic of South Sudan as amended, read together with the provision of Regulation 62 and 63 of the Transitional National Legislature, which is here. This is our Constitution, and this is here. This read together with the provision of Regulation 62 and 63 of the Transitional National Legislature, Conduct of Business Regulation 2013, amended 2021, provided that the first Vice President shall not be subjected to criminal proceeding while in office. except upon proper removal of immunity upon a resolution passed by a two-thirds majority of all members of the National Legislature. Article 104, Clause 2 of our Constitution reads as follows. The Vice President may be removed by the President or by two-thirds majority of all members of National Legislature. The provision of Regulation 62 and 63 of the Transitional National Legislature Conduct of Business 2013 as amended 2021 entitled Immunity and Impeachment of the President, the First Vice President, and the Vice President. Regulation 62 read as follows. Impeachment of the President. The President shall be immune from any legal proceeding and shall not be charged or sued in any court of law during his or her tenure of office. 2. Notwithstanding sub-article 1 above, in case of high treason, gross violation of this Constitution, or gross misconduct in relation to national affairs, the President may be charged before the Constitutional Panel of the Supreme Court in the Republic of South Sudan, and upon a resolution passed by a two-thirds majority of all the members of the Assembly. Clause 3. The President of the Supreme Court shall within 7 days after receipt of the impeachment notice referred to under sub-article 2 above, constitute a tribunal comprising 3 justices of the Supreme Court to evaluate the allegations in the notice and to report to its findings to Constitutional Panel of the Supreme Court. Number 4, Clause 4. The President shall be entitled to appear at the proceeding of the tribunal and to be represented by a lawyer or other expert or any other person of his or her choice. Number 5. If the Constitutional Panel convicts the President, it shall communicate its final verdict to the Assembly, and he or she shall be deemed to have fulfilled the office. Your Lordship, this provision is applicable to His Excellency, the First Vice President, according to provision of Regulation number 62, 63 of the Transitional 2013 as amended 2021, which read as follows. Regulation 33, removal of the First Vice President and the Vice Presidents. The provision of Regulation 62 shall, with necessary modification, apply in respect of the First Vice President and the Vice President. The question arises here is, when does a court become competent? A court becomes competent when it is properly constituted as regards members and qualifications of the members of the bench, and no member is disqualified for one reason or the other. Number 2, the subject matter of the case is within its jurisdiction and there is no forfeiture in the case which prevents the court from exercising its jurisdiction. And 3, the case comes before the court initiated by due process and upon fulfillment of any condition precedent to exercise of the jurisdiction. My Lord, Your Lordship, any defect to these 3 points on competence of the court is fatal. For the proceeding are nullity, however well conducted and decided. The defect is extrinsic to the adjudications. For the above legal points 1, 2, and 3 go together in the circumstances of the instant case, the 3 points were not fulfilled for the following ground. 1. The Honorable President of the Supreme Court of South Sudan has no jurisdiction to constitute a special court in case of the first Vice President, His Excellency Dr. Riek Machar, our first Vice President of the Republic of South Sudan, which is subject to impeachment upon resolution passed by a two-thirds majority of all members of National Legislative Assembly provided in the provision of Article 104, Clause 2 of the Constitution of South Sudan, read together with the provision of Regulation 62 and 63 of the Transitional National Legislature Conduct of Business 2013 as amended 2021. There, the order of establishment of this Honorable Special Court by Honorable the President of the Supreme Court of South Sudan is ultra-vires, beyond its mandate. It is unconstitutional, it is illegal, it is unlawful. There, the sitting here is wasting of resources and time. That beyond his jurisdiction for him in the provision of Section 16(4) of the conduct of our Criminal Code of Procedure. The only power of our President of the Supreme Court is only to constitute or to establish a special court for trial of juvenile offenders. These are not juvenile. To form high court to preside, convince of preside, the special court to be presided over by the High Court or any senior justice, which is not the case here in the case of the first Vice President. And number three, a High Court judge may convince a special court. This is not relevant. It is irrelevant. So, which is to play that the President of the Supreme Court may, by order, constitute a special court for the trial of any accused under Chapter 4, Chapter 5 and 7 inclusive of the Penal Code. Number two, lack of a resolution passed by two-thirds majority members of all members of the Transitional National Legislature Assembly as provided in Article 104, Clause 2 of the Transitional Constitution, read together with the provision of Regulations 62 and 63 of the Transitional National Legislature Conduct of Business 2013 as amended 2021. Therefore, the arrest and detentions of the first accused, His Excellency Dr. Riek Machar and his brothers, were carried out without lifting the immunity, rendering this proceeding unconstitutional, unlawful, illegal, and void ab initio. The right to be tried before a competent court, independent and impartial tribunal is guaranteed under both international treaties ratified by the Republic of South Sudan and the Bill of Rights in Part 2. Bill of Rights is here in Part 2 of our beautiful Constitution, from Article 9 through Article 34 of our Constitution. It is about the Bill of Rights, it is about human rights, it is about the due process of the law, it is about the crash of the whip. Number three, relief sought. Wherefore, His Excellency Dr. Riek Machar and the 7 accused persons respectively pray this Honorable Special Court to order in their favor as follows. Number one, order this Special Court lacks of jurisdiction and competence to try this matter, and therefore null and void ab initio pursuant to the absence of fulfillment of the requirements stipulated in the provision of Article 104, Clause 2 of the Transitional Constitution, read together with the provision of Regulation 62 and 63 of the Transitional National Legislature Assembly Conduct of Business 2013 as amended 2021. Number two, order the immediate discharge, release, and go home of His Excellency Dr. Riek Machar and his brothers from this court, and let them go home from today. Let them go home and have the business to do their job. Order the immediate discharge of His Excellency Dr. Riek Machar, the first Vice President of the Republic of South Sudan, and the 7 accused persons for being arrested and detained unconstitutionally. Number three, Your Lordship, any other relief this Honorable Special Court deemed fit, respectively submitted, date today, 22nd day of September 2025, Defense Advocate Dr. Gary Raymond Lege Lobate, the lead advocate. Number two, Advocate Kurlu Alkur, member. Number three, Advocate Deng John Deng, member. Number four, Warnyang Kiir Warnyang, member. And finally, Advocate Anis Tombe Agustino, member. All, thank you so much. Thank you, my lordship.
Hearing the application of the defense, now we would like to give chance to the prosecution to reply. My Lord, allow us to reply to our colleague, Dr. Jerry, for what he has raised of his objections. This will be represented by one of the panel, Advocate Dual. Your reply, in writing or verbally?
We will make it because my lord will give an oral reply and we'll give you a snapshot of our reply.
And then you...
Yes, we'll give you a snapshot.
And then...
My lordship, we object to these oral submissions. We are making history. Your lordship, we object these oral submissions. We are making history. The Republic of South Sudan is doing all levels of government, represent them in public prosecution, litigation, education, and conduct free trial proceedings. They shall recommend reform, strive to protect public and private rights, advise on legal issues, and shall render legal aid. This is a constitutional requirement. It is mandatory. It is peremptory. If we are not in a state of emergency, there is no any state of emergency which allow private lawyers to come. They are all there and they are competent to do the job, not anyone who is private. That is why we are here. Therefore, I call upon this honorable court to send them out to sit outside there with our brothers who are sitting there. And because to appear in this honorable court is a constitutional right, we don't object on that. They can move from here and sit with our brothers and sisters who are outside there. Thank you, my lord.
Okay. Let us separate between two things. You see, you are now like raising another point of objections, which is, in our view, will be a separate point. As for the reply, we think, as they told us, that they will provide a written reply, and now he's giving us the summary of that reply. Please continue.
Thank you. Thank you, my lord. I would proceed to provide our response response to the defense objection. My Lord Justice, the first ground of legal objection is on the supremacy of the revitalized agreement on the resolution of conflict in South Sudan 2018. It is the argument that the revitalized agreement shall take precedence over any national legislation, any existing agreement to the contrary, and in the event that the provisions of a national legislation or previous agreement conflict with the terms of this agreement, the provisions of this agreement shall prevail. My Lord, this argument finds no basis in law. First, there is no conflict between the revitalized agreement and the law, so as to invoke the provision of Article 8.3 of ACES. My Lord, in terms of competence of this court to try the first vice president, it is a prosecution argument that this court is competent to try the first vice president. My Lord, presiding justice and justice of the special court, Article 123E establishes the structure and hierarchy of our judiciary. And under E, it empowers that there shall be established other courts and tribunals as deemed necessary to be established in accordance with the provision of the Constitution and other law. This provision of the Constitution is reiterated, my Lord Justices, in Section 7F of the Judiciary Act 2008. As to the rules that shall apply to such other courts as shall be established, my Lord Justices, Section 9 of the Judiciary Act provides for the same. In terms of paneling of this special court, my Lord Justice, Article 126(3) of the Transitional Constitution 2011 as amended provides for paneling of special courts. That, in case of criminal or civil matters, there shall be panels of 3, and when they sit as a constitutional panel, there shall be at least 9 justices, where the Chief Justice shall be presiding. The same provision is reiterated in Section 11(3) of the Judiciary Act. It is based on this narrative and sequence of law, my Lord Justices of the Special Court, that this Special Court is established by this order of establishment, referenced as JOS, in -CJ, J, AO, 1, 2025, dated 1st September 2025. Under Section 16(4) of the Code of Criminal Act, it provides that the President of the Supreme Court may, by order, constitute a special court for trial of any person accused under Chapters 5 and 6 of the Penal Code Act. My Lords, as you might have seen in the charge sheet, the offences with which the accused persons are charged are all under Chapter 5 and 6 of the Penal Code Act, which are offences relating to offences against South Sudan, as well as offences relating to the armed forces of the Republic of South Sudan. The same provision, the same reality is reiterated in Section 44 of the Code of Criminal Act, empowering the Chief Justice to constitute this special court. My Lord Justice, the arguments that this court lacks competence to try the first Vice President by virtue of Article 126G of the Transitional Constitutional Republic of South Sudan 2011 as amended. These claims, my Lord, are unfounded. This article provides that the Supreme Court shall exercise competencies as follows: have criminal jurisdiction over the Vice President, the Speakers of the National Legislative Assembly, and of the Council of States, and the Justices of the Supreme Court. It is the assertion of the defense that based on this court, the special court is not a Supreme Court, and therefore lacks competence to entertain this matter. My Lord, this argument is weak and lacks substance. The members of this special court are all justices of the Supreme Court, and therefore competent to entertain the matter by virtue of the laws as stated. Even if the powers given are powers of the High Court has unlimited jurisdiction, and therefore the crimes committed based on Chapter 5 and 6 are within the competence of the High Court powers. My Lord, there is an argument from the defense team that Article 126G deals with the office of the Vice President. We argue that Article 126 deals with the office of the Vice President. The fifth accused is not the Vice President, but the first Vice President. It is the argument, of course, that under Article 1042, he is not to be impeached. This is their language. He is not to be removed by virtue of Article 1042 unless there is a decision passed by 2/3 majority of all members of the National Legislative Assembly. My Lord, this is a misdirection to this court. This is not a session to remove the first Vice President. This is not a session to impeach the first Vice President. This is a court proceeding within the competence of the judiciary of the Republic of South Sudan, and has nothing to do with his office or removal from office. Notwithstanding this argument, my lords, allow me also to assert this: that Article 126G deals with the office of the Vice President. The fifth accused person is not the Vice President, but the first Vice President. His office is the creation of RSS, and by virtue of Article 1.4.3.5 of RSS, it was incorporated in the Transitional Constitutional Republic of South Sudan through the Transitional Constitution of Republic of South Sudan Amendment number 6 of 2020. Article 104 establishes his office. Article 104A and Article 104B designate his powers, functions, and responsibilities. My Lord, Article 126G of the Transitional Constitution was not amended specifically by inserting the word first Vice President in the text to reflect this new reality. If it was intended by RSS or the National Constitutional Amendment Committee, the amendment would have occasioned such. For instance, in the amendment number 6 of 2020, Article 92 of the Constitution was amended by inserting the words first Vice President, for Vice President between the words President and the words National Council of Ministers. The fact that this was not done with Article 126G of the Transitional Constitution means that it was not intended to cover the first Vice President, hence the competence of this court to entertain this matter. My Lord Justices, there is an argument on the immunity of the first vice president. The defense claim of immunity, my lords, is legally bankrupt within the framework of South Sudan laws. It finds no support under Article 103(1) of the Transitional Constitution or the Revitalized Agreement on the Resolution of Conflict in South Sudan. First, my lords, immunity provided for under Article 103 is for the president and is in clear black and white. Only for the president and not for the presidency. The amendment number 6 of the Constitution in the interpretation provision defines presidency to mean, that is section 3 of the amendment, Constitutional Amendment Act number 6 of 2020 defines presidency to mean the president himself, the first vice president, and the 4 vice presidents. However, goes ahead to define the president to mean the president of the Republic of South Sudan. These definitions, as stipulated in the Constitution, my Lord Justices, clearly demonstrate the fact that the two are different and distinct. Immunity is a creature of statute and law. Notwithstanding this, immunity is not an absolute privilege. Even the President of the Republic can suffer a charge in cases of high treason, gross violation of the Constitution, or gross misconduct in relation to our national affairs if there is a resolution passed by the National Legislative Assembly. Secondly, my lords, under the Revitalized Peace Agreement, this argument has no legal basis. Article 1.4.3.5 of the Revitalized Agreement, Article 1.4.3.5 of the Revitalized Agreement, provides for the incorporation of the Revitalized Agreement into the Constitution. This was occasioned by amendment, the Transitional Constitution of the Republic of South Sudan Amendment Act number 6 of 2020. So by that act, the Revitalized Agreement became part of the Constitution. My lords, when this amendment was done, Article 103 as a whole was not amended to extend the immunity to the presidency as a collegial body, but maintained as a privilege to be enjoyed by the President of the Republic alone. If it was intended to cover the first vice president or the other vice presidents in the presidency as claimed, Article 103 would have been amended when the assets was being incorporated into the Constitution. That was not done. My lords, the lead defense counsel, Dr. Gary Raimondo Lege, Lubate, further proceeded to bring provisions under the Transitional National Legislative Conduct, Transitional National Legislature Conduct of Business Regulation 2013, amended 2021. Specifically, rules 62 and 63. My Lord, with due respect, these are irrelevant provisions. Provisions that has no bearing with the matter before us. Provisions that speak to how we do not take this matter with the seriousness it deserves. Provisions that speak to us not taking zealously our obligation to prosecute the case. My Lord, before we conclude our response to defense preliminary objection. Allow me to give the mic to my senior, Gilberto Manuat, to respond on the matter of hybrid court competence in this particular matter and not why this special court.
My lords, justices of this honorable special court, I will take response to the argument for the hybrid court to be the competent court for the trial of the offenses for which the accused stand to be tried. Let us first assert that the special court is one of the courts under the judiciary of the Republic of South Sudan, constituted by the Chief Justice, who has authority under the national constitution to constitute such courts. Now, the argument for the hybrid court to be the competent court for the offenses brought against the suspects standing before this court tantamounts to advocacy or advocation for impunity to prevail in the country. Why? Because South Sudan is a sovereign country having a functional government, and it is having the responsibility of providing security to its people. Now, do we have to just wait for a court that is to be constituted by African Union to investigate and prosecute cases specified therein, when acts amounting to gross violations of the laws of the land have been committed, abetted, conspired for by some of the actors who are signatories to the RRCs. Now, it is very clear in the charge sheet that the offenses that have been brought forward against the suspects include offenses of mass murder and offenses related to terrorist activities. Now, can we say that Nasser incident, which was orchestrated or basically carried out by the so-called White Army and not the SPLA as a signatory to the RRCs, can be left for hybrid court, which is to be constituted? In summary, my lords, it is our conviction that this special court, having been constituted by the Chief Justice, using his powers as stipulated under the Constitution, is competent to try the accused before it, including the first Vice President, Dr. Riek Machar. Thank you.
justices. In summary, my senior asserts that the High Court under Article 5.3 under Article 5.3.2.1 of RSS prescribes and restricts the jurisdiction of the High Court to crimes of genocide, crimes against humanity, and war crimes, and other serious crimes under international law, and relevant understood, misleading, and contrary to the statutory and constitutional mandate of this court.
The prosecution, when will they bring the response in writing before you continue?
Your Honor, we have given them copies of our snapshot. If you want detailed one, we can provide by after lunch, if it's needed, or even tomorrow morning. So if you don't mind, give us until tomorrow morning. We can provide, because we have details of maybe case laws, which we will need also to print out and share for the consumption with this honorable court.
You must submit full defense. Reply, please.
Most obliged, my lord.
After lunch?
Tomorrow morning.
Tomorrow morning.
Most obliged, my lord.
Yeah, so this is the Togiri. You wait for their reply so that you continue tomorrow.
I do agree with the Honorable Special Court, because we are not in haste. We are laying a foundation to this country, the rule of law.
And thank you. Now, the session is going to be adjourned for tomorrow. The same time, please. Jalsa.
Go!
نعم أيها السادة والسيدات في كل مكان تتابعون البث المباشر لSBC الجلسة الأولى لمحاكمة أو جلسة الاستماع الأولى لمحاكمة دكتور رياك مachar النائب الأول لرئيس الجمهورية الموقوف و7 من المتهمين في قضايا تتعلق بالقتل الجماعي، الإرهاب، تمويل الإرهاب وتدمير الممتلكات العامة والعسكرية، وذلك تباعا لأحداث الناصر. وهذه الجلسة تم تأجيلها ليوم غد إن شاء الله في تمام 9 صباحا، وذلك انتظارا لرد هيئة الاتهام. وكان هيئة الدفاع قد رفع اعتراضا لإقامة هذه المحكمة نسبة لعدد من الأحكام حسب لجنة الدفاع يتعلق بعدم دستورية هذه المحكمة، لكن هيئة الاتهام أشار إلى أن هذه المحكمة أقيمت طبقا للدستور الانتقالي لجنوب السودان، وأيضا اتفاقية السلام المنشطة التي تم دمجها في الدستور الانتقالي. وهذه الجلسة سوف تتواصل يوم غد في 9 صباحا. الآن آتي الميكروفون لزميلة ليلى عثمان وبقية الزملاء لمواصلة التعليق.
Thank you very much. Continuing to SSBC, the court sessions has just ended. The session will be adjourned tomorrow for further hearing of this high-profile case involving Dr. Riek Machar and the 7 other accused colleagues. For more details, we'll keep updating you. Then let me give over to Martin Joseph. Sorry, Mori.
Thank you, my colleague Leila Osman, viewers and listeners of SSBC. To hear this first hearing of the session of the trial of Dr. Riek Machar, the suspended first vice president, and the co-accused have been adjusted for tomorrow due to some legal documents. Now, decision will continue tomorrow because the legal defense team of the accused persons have raised some concerns on the illegality of the constitution of this court. They said the constitution, the special court to try this accused is illegal, and that the first vice president is still a sitting vice president. So, based on the constitution of the Republic of South Sudan as amended, he's supposed to be tried by the Supreme Court, not a special court constituted by the judiciary. And the prosecution is saying that the special court constituted by the Minister of Justice has all legal rights. With this, let us go back to our studios with our colleague Gore Anthony. Gore Anthony, you are welcome.
In the first session of the proceedings and trial of the Dr. Riek Machar and 7 other accused that has been taking place at Freedom Hall since morning. We've been covering for you this event. This is in the fact that the government wanted everything to be on the public domain, that this matter has to be consumed by the public. For its nature, it requires attention of the public, and the public must know what has happened or what is happening in the country and how the government is trying to make sure that rule of law is kept or rule of law is adhered to by everyone who is part and parcel of this government or citizens of the Republic of South Sudan. Of course, the proceedings of the court is started by allowing the presiding over judges to give some rules or regulations of the court, of which was given to all those who happened to attend. And we do remember that the people who attended the court and then we don't forget that families of those who are accused also happen to be part and parcel of this event or these legal proceedings that took place in Freedom Hall. Before the judge or the presiding over could actually adjourn the court for tomorrow, which is going to be on Tuesday, there was some proceedings, some process that were allowed for the defendant as well as the prosecution's team to be able to actually air out their point of view regarding the case at hand, the case of the accused and co-accused, the suspended first vice president, as well as the suspended minister of petroleum, Potkang, as well as the other accused who happen to be some of them, which are including Mompal. We have Gabriel Doplam. We have Camilo Gatmai. We have Gabriel Doplam, including Madin Yak, Riek, and Dominic Gatkov. Actually, all the accused happened or appeared before the court today, and in the attendance, they have registered their presence. This shows that the matter at hand will be given top priority, and the leadership and the country and the leadership of the country actually expresses so much confidence that this matter will be addressed and will always be given to the public for the consumption. Of course, during the court process, prior to its start or prior to its commencement, we have a number of prosecution team comprising of a number of lawyers and advocates, actually headed by Advocate Ajo Ohisa. Then we have Advocate Gabriel Madin. We have Advocate Deng Mabor. We have Advocate Philip Nyang. We have Advocate Ajak Mayor Bior. We have Advocate Jeremiah. More than 8 advocates from the prosecution team were present at the court today, and they have raised a number of concerns that will be also looked at by the defendant prosecution team. And on the other hand, the team of the prosecution or the team of the defendant that are being hired by the family of the accused or by the family of Dr. Riek, these are led by advocate Dr. Gary Raimondo Lege, who happened to be the lead or the lead counsel of the defendant team, and include some of them in the list. We have also advocate Kur Lual, member of the defense team. We have advocate Anis Tombe Agustino, member of the advocate team, or member of the defense team rather. We have advocate Deng John Deng, member of the defense team, and we have advocate Wurnyang Kiir Wurnyang, member of the advocate team. So then we have Regina Akero Deng, member of the defense team. But they have raised a number of concerns, like some of you may have heard. They have especially given a concern that is a preliminary concern to the presiding over judges by saying they don't agree with the legality of the formation of the special court due to some of the articles that they have cited in the agreement, as well as the transition constitution of the Republic of South Sudan. And the defense team, of course, during the proceeding or during the hearing, were given a chance that they will have to make a response to the defense preliminary objections of the constitution of the special court. This will be in writing, which will be tomorrow in the morning. The defense team is actually requesting that they should have some time to be able to articulate or write accordingly to what is actually based on the accusation. So, based on the formation of the court, the defense team are saying they wanted a response to that. The presiding over judges, of course, has given ample time from now onward till tomorrow for the prosecution team, which is comprising of more than 8 advocates and some legal team. They will be able to respond to what the defendant team or defense counsel team required. And this will actually move us to the next session of the court, which has been done or which has been actually talked to by the judge or the presiding judges, who are 3 in numbers, and they have to make sure they go through this process until the accused, either they are being proved innocent or guilty, as the process of the court continues. Once again, viewers of SSBC, back on the days, this culmination of this process is due to the Nasir incident that happened and resulting to the killing of more than 290 SSBF soldiers, plus Major General who happened to die during that event, and Major General Majur, who happened to be killed during that event. With that, viewers will say that has finally brought us to this event or this coverage, live coverage of the special court proceeding or hearing for Dr. Riek Machar and the 7 other accused. Rule of law and fairness in trial and impartiality are the guiding principles to ensure that the rule of law is adhered to and the court bring to an end what has been happening. With that, all we say thank you for tuning into SSBC, and thank you to those who happen to join us. And SSBC will keep on updating you on what is happening with the court and with this special case. Thank you so much for joining us, and bye for now.